Hello, everyone, and welcome back to Corporate and Securities Law Compass. Let me start with an important question. If a portfolio manager invests a client's money in the units of an alternative investment fund, AIF, should those AIF units be treated like mutual fund units for calculating the Prudential Investment Limits under the SEBI Portfolio Managers regulations? At first glance, the answer may seem obvious. After all, both mutual funds and AIFs are pooled investment vehicles. But what if I tell you that SEBI has now clarified that the answer is actually different from what many market participants believed? This clarification has significant implications for portfolio managers, compliance officers, investment managers, company secretaries, legal professionals, and everyone working in the financial services industry. Today, we are discussing a very important SEBI informal guidance that every professional in the securities market should understand. Although it appears to be just a simple clarification letter, it can completely change the way prudential investment limits are interpreted under the SEBI Portfolio Managers regulations. Many professionals assumed that AIF units should receive the same treatment as mutual fund units because both are pooled investment vehicles. However, SEBI has now provided its official interpretation, and the conclusion is likely to surprise many market participants. So, stay with me till the end because I will explain the complete background of the case, the relevant legal provisions, the specific question raised before SEBI, SEBI's legal reasoning, and finally, the practical implications for portfolio managers and the entire financial services industry. Let's begin by understanding the question that was placed before SEBI. Why did this question become so important? Now, before we look at SEBI's answer, let's first understand why this question became so important in the first place. Imagine this practical situation. An investor already holds units of an alternative investment fund, AIF. Later, the same investor opens a portfolio management services, PMS account with the same financial group. Now the investor wants to transfer those existing AIF units into the PMS account. At first glance, this may appear to be a routine transfer. But here's the real question. Should those AIF units be treated in the same manner as mutual fund units, which enjoy a specific exemption under the SEBI Portfolio Managers regulations? Or should they instead be counted while calculating the prudential investment limits applicable to investments in the securities of associate companies? The answer to this single question can directly affect whether a portfolio manager remains compliant with SEBI's investment restrictions. And this was exactly the issue that was placed before SEBI for its official clarification. The relevant regulatory provisions. Now that we understand the issue, the next question is, what does the law actually say? Because in securities law, the answer always lies in the wording of the regulation. Let's examine the relevant provisions. Regulation 24(3)A of the SEBI Portfolio Managers Regulations requires every portfolio manager to comply with the prudential investment limits specified by SEBI. These limits are further prescribed under paragraph 3.4 of the SEBI Master Circular for Portfolio Managers. Now, what do these prudential limits say? The Master Circular provides that a portfolio manager can invest in the securities of its own associates or related parties only up to the prescribed limits. The objective is to prevent excessive exposure to connected entities and to safeguard the interest of clients. But here's where the controversy begins. An important clarification is contained in paragraph 3.4.3 of the Master Circular. This paragraph clearly states that these prudential investment limits apply only to direct investments made by the portfolio manager in the equity, debt, and hybrid securities of its associates. And then comes the most important sentence. The paragraph expressly provides that these prudential limits do not apply to investments in mutual fund units. This single exception gave rise to the entire controversy. If mutual fund units are specifically excluded, what about alternative investment fund AIF units? Should AIF units also receive the same exemption because they are pooled investment vehicles? Or did SEBI intentionally restrict this benefit only to mutual fund units? That was the precise legal question placed before SEBI for its interpretation. The applicant's argument. Now comes the most interesting part of the case. The applicant, Sundaram Alternate Assets Limited, placed a very logical argument before SEBI. The company submitted that alternative investment funds, AIFs, are also pooled investment vehicles. Just like mutual funds, AIFs collect money from multiple investors and invest those funds in accordance with a defined investment strategy. So the applicant raised an important question. If mutual fund units are excluded from the Prudential Investment Limits, then why shouldn't the same benefit also be available to AIF units? Based on this reasoning, the applicant argued that if an investor transfers existing AIF units into a Portfolio Management Services (PMS) account, those AIF units should also be excluded while calculating the prudential investment limits. In simple words, the applicant wanted SEBI to extend the same exemption that is available for mutual fund units to AIF units as well. This was the interpretation sought from SEBI through the informal guidance mechanism. SEBI analyzes the law. Now comes the question that everyone was waiting for. Did SEBI agree with this interpretation? To answer this, SEBI carefully examined the language of the regulations. The regulator first observed that paragraph 3.4.3 of the Master Circular specifically mentions only one category, mutual fund units. There is absolutely no reference to alternative investment funds anywhere in that exemption. SEBI then examined the legal framework governing AIFs. The regulator noted that alternative investment funds are defined under the SEBI Alternative Investment Funds regulations and operate under an entirely separate regulatory regime. On the other hand, mutual funds are governed by a different set of SEBI regulations, have a different legal framework, different compliance requirements, and cater to a different category of investors. This distinction became the turning point of the entire case. SEBI clarified that merely because both mutual funds and AIFs pool money from investors does not make them legally identical. In law, similar commercial characteristics do not automatically result in identical regulatory treatment. And this principle ultimately became the foundation of SEBI's final conclusion. The most important conclusion. Now comes the biggest takeaway from this entire guidance. After analyzing the regulations, SEBI gave a very clear and categorical clarification. Alternative Investment Fund AIF units are not equivalent to mutual fund units for the purpose of the Prudential Investment Limits under the SEBI Portfolio Managers regulations. As a result, the exemption specifically available to mutual fund units cannot be extended to AIF units. Here, wherever AIF units are transferred into or held within a Portfolio Management Services (PMS) account, those investments continue to remain subject to the applicable prudential investment limits. That is the essence of this entire informal guidance. Why this guidance is important? Now, you may be wondering, why does this clarification matter so much? The answer is simple. This guidance has significant practical implications for the financial services industry. First, portfolio managers can no longer rely on the argument that AIFs are pooled investment vehicles to claim the exemption available to mutual fund units. Second, Compliance officers must include transferred AIF units while calculating prudential exposure limits and monitoring regulatory compliance. Third, investment managers should review their existing PMS portfolios and structures to ensure that they remain fully compliant with SEBI's requirements. Fourth, legal and compliance teams drafting transfer documents or advising clients should revisit their assumptions in light of this clarification. And finally, every future transaction involving AIF units of associate entities should be carefully examined before execution to avoid any unintended regulatory breach. Industry impact. Although this informal guidance was issued in response to a query from one applicant, its significance extends far beyond that individual case. It provides valuable insight into how SEBI interprets the portfolio manager's regulations. That is why this guidance deserves careful attention from portfolio managers, alternative investment fund managers, merchant bankers, compliance professionals, company secretaries, legal advisors, fund managers, trustees, and institutional investors. For all of these stakeholders, this clarification serves as an important reference point while interpreting and applying the prudential investment provisions. Key takeaways. Before we conclude, let's quickly recap the 5 most important points. Number 1. Mutual fund units continue to enjoy the specific exemption provided under paragraph 3.4.3 of the SEBI Master Circular. Number 2. Alternative investment fund units are not treated as mutual fund units merely because both are pooled investment vehicles. Number 3. Transfers or investments involving AIF units in PMS accounts remain subject to the Prudential Investment Limits prescribed by SEBI. Number 4. Portfolio managers should reassess their internal compliance policies, exposure monitoring systems, and investment approval processes to ensure continued regulatory compliance. Number 5. And perhaps the most important lesson. This guidance reminds us that regulatory interpretation is based on the precise language of the law, not on commercial similarities between financial products. A product may appear similar in practice, but unless the regulation expressly provides the same treatment, SEBI will interpret the law based on its exact wording. If you found this explanation useful, please like this video, subscribe to Corporate and Securities Law Compass, and press the bell icon so you never miss our detailed analysis of the latest SEBI regulations, Companies Act amendments, RBI circulars, and important developments in corporate and securities law. Thank you for watching, and I'll see you in the next video. Welcome to Corporate or Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a company secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. The content published on this channel does not represent the views, opinions, policies, or official position of my employer, any company with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. All examples, case studies, and discussions presented on this channel are based on publicly available information, applicable laws, statutory provisions, judicial pronouncements, regulatory materials, or are purely hypothetical for educational purposes. I do not disclose, discuss, or use any confidential, unpublished, or proprietary information obtained through my professional employment. I fully comply with the SEBI Prohibition of Insider Trading Regulations 2015, the Companies Act 2013, applicable laws, professional confidentiality obligations, and the internal policies of my employer. Nothing contained in this channel should be interpreted as the communication, disclosure, or use of unpublished price-sensitive information (UPSI) or any information that may violate insider trading laws or other legal obligations. This channel does not provide legal, tax, investment, financial, accounting, or any other professional advice. The content is intended solely for educational and informational purposes. Viewers should consult qualified professionals before making any legal, business, compliance, taxation, accounting, or investment decisions. Although every reasonable effort has been made to ensure the accuracy and reliability of the information presented, laws, rules, regulations, circulars, and judicial interpretations are subject to amendment and change. Accordingly, neither the presenter nor this channel shall be responsible or liable for any loss, damage, liability, or consequences arising from the use of or reliance upon the information provided. All company names, trademarks, logos, and brands belong to their respective owners and are used only for educational, news reporting, review, and commentary purposes. Sarvadhikar Copyright Corporate and Securities Law Compass Navigating Law with Clarity. All rights reserved. By accessing or viewing this channel, you acknowledge that you have read, understood, and agreed to the terms of this disclaimer.